Later, I'll show some example how to strategize your will. Now, a will can only be used to distribute this item. If you are a business owner, business, investment, if you have investment. Now, if you have properties, yes, but it depends on how your property is being held, which later I'm going to share about properties. Cash, if you have, definitely all of us have cash, so cash, insurance, and then CPF. CPF, we can't use will. All right, the other 5 items we can use will to distribute. CPF cannot. Your will never distribute your CPF. It's either for CPF, it's only nomination. Now, if you don't have a nomination for CPF, it follows ISA, Interstate Succession Act. A will cannot distribute your CPF. Take note of that. So I always hear people talking about, put the CPF inside the will. No, it's not. You can't do that. You can't do that. Okay, so your will can only distribute these 5 items in the local context. Okay, property ownership. Now, let's say a couple, husband and wife, owns a property under joint tenancy. So most property will be held under joint tenancy in the past. Okay, joint tenancy, what do we mean by that joint tenancy? When one party dies, okay, automatically the party share is transferred to the surviving partner, okay, or the surviving owner. Automatically, you do not need to use a will to distribute that. Okay, automatically you'll transfer to the survivor. All they need to do is with the death cert, the family members go to, if it's a private property, SLA Novena. If it's HDB, go to HDB Center to actually do the transfer. You don't need to look for a lawyer. You do not need to look for a lawyer. You do not need to, all right, you do not need to draft a will to talk about this property. If your property is held under joint tenancy, no need to engage lawyers, so save the money, just go there straight away.
Does it matter if there's a mortgage on the property?
Then I will talk about that, sir, next one. Okay, so take note of that. All right, so joint tenancy. And most of the property for couples are held under joint tenancy. So if you are not aware of it, check your title deed. All right, whether your property is held joint tenancy or tenancy in common. Sometimes it's good to have joint tenancy, sometimes not. Okay, later we discuss it. Okay, on the other side, properties can also be held under, example, sole owner. So if you are the only owner, all right, maybe example, you invest in it, or you are the surviving owner now. Okay, so you are the sole owner. Now, as a sole owner, yes, this property can be willed away via a will. Okay, so if you are the sole owner, you can will. Okay, or through nominee. Now, what do we mean by through or through nominee? In some property, all right, what happens is that you may invest with others. Your name is not in the property, but you give money to someone else to be your nominee. That one, you need to have a will to mention about it. So example, I share an example. Let's say I and John, okay? John is easy to borrow money from the bank because he's very rich, so very easy to borrow money. People like me, very difficult to borrow. So I said, John, let's invest in the property, okay? Because it's private property, cannot put my name, use John's name. And I'll issue a check to pay for the property. Okay, my name not inside, just use your name. But we do own investment. Let's say I own 50% of it, but John is the sole owner. Now, a few things will be a concern. If John were to pass away, his will don't have, never mention about the property is gone. Because my name is not in the property, that's the first part. Second one, in my will, if I don't mention anything about that property that I invest in with John, when I pass on, my family may not be aware of it, and then it leak out on my estate. Then my family cannot take back that investment with John. So we need to do a few things to address that. One example will be a legal document that we do is what we call a declaration of trust. We do a declaration of trust that says, John will do a declaration of trust to say he's holding on my behalf. Okay, John is doing a declaration of trust to say holding on my behalf. I also get John to write a will. I will also write a will. All right, so we will do that to protect my interest if, let's say, I have a nominee. So this is where property. So any of you have done property investment such way? Okay, no one? Okay, good. Next, this is another one very common. Let's say a couple again. But this time around, the property is not held under joint tenancy. The property is held tenancy in common. Now, tenancy in common, what do we mean by that? When one party dies, it's not automatically transferred to the surviving partner. It goes to the estate. Okay, the estate means it goes to the estate to see whether this person has a will or he passed away without a will. Without a will, ISA will distribute. So if ISA, that means there will be a lot of beneficiary coming to join this, to own this property. Take note. When there's too many people owning the shares of a property, when one party don't want to sell, the rest cannot sell. Even though that party owns just 1%, if he or she don't want to sell, cannot sell. So it doesn't make sense to have too many further owning a property. All right, it's always like that. Alright, so take note tenancy in common. So your property most commonly in Singapore is either joint tenancy or tenancy in common. But if you invest in Malaysia, for those people who invest in Iskandar, our neighbor, Malaysia, Johor, properties in Malaysia will only be held under tenancy in common, will not be joint tenancy. Okay, in Malaysia, all tenancy in common, no joint tenancy arrangement. Okay, only Singapore, joint tenancy and tenancy in common. Alright, so what happens is that if you invest in JV, take note, you must plan properly how this property will be distributed. And the ISA must follow Singapore. If you pass away, right, you make sure you have a will. If not, it follows Malaysia ISA rule. Malaysia ISA rule distribute differently from Singapore. So moral story is be careful where you invest in. Singapore is easy. Outside Singapore is very tough. Okay, you need to plan properly before you invest. Okay, another way to own a property, usually for commercial, is via a company. Okay, via a company to own a property. Okay, in Singapore, we can't, for private property, we can't use company, but for commercial property, it's still very common to use a company, sometimes for GST or whatever. Okay, so what happens in this situation, it's held by a company, you need to will the company. Okay, so you need to have a will to talk about this company upon your death, how you transfer your shares to your loved one. Okay, so you own a property via a company. Now you need to have a will mentioning this property. Same thing. If you sell away your property, you transfer the share of this company to the new buyer. Alright, so it's very common now for commercial investment to use a company instead of their own personal name. Okay, so now let's start with lack of proper planning. So in will, a lot of people, never thoroughly talk to an estate planner. They just draft the will. What are the common issues that a lot of people overlook? Number one will be liabilities. Okay, liabilities. Especially in property investment, you always have mortgages, right? Most people will borrow. Now, men declare that, this is a Straits Times article, December 2010. Man declared bankrupt after his death. He was not declared bankrupt when he was alive. He died already, then declared bankrupt. Okay, he died already, then he declared bankrupt. What happened is that this person was a very successful business owner. Okay, and he borrowed to the max with the bank. But he died at the wrong time. He died before his business project finished. He's a contractor, so they call it project financing. Before the project finished, he died. He died at the wrong time. Friends, anyone died at the right time or not? Everyone died at the wrong time. Where got people die at the right time? Alright, so he died at the wrong time. So he died before the project finished. So his company was unable to pay back the loan, unable to complete the project. Then the customer claimed the money, insurance, bond, all that, they pay out, and then the bank claw back all the loans and whatsoever. And then the company do not have sufficient funds to pay off the loan. So the bank says, never mind, if you can't pay, we go to your estate. He went to his estate to look for money. Estate means in his will, let's say he said, I give 1 million to my son. I give this property to my daughter. Cannot be transferred. The bank has the first right to it. Right? Because there was insufficient to pay off the loan, the bank declared him a bankrupt after his death. Okay, so he went over to the other side and then he declared bankrupt. Cannot come back again. Alright, so very sad. I said, at least when you're alive, you're declared a bankrupt. Alright, you still can discharge. He go there permanent bankrupt. Okay, so very sad. Alright, I can take it lightly, but just take note, it's true. Alright, so when you have mortgages, especially property, when you have mortgages, take note that you need to, in your will says, how to address the loan. If you have mortgage insurance, it will be good. If you don't have, you must address the loan. In your will, you must say that your estate must pay for the loan. Now, if you don't mention about the loan, there's outstanding loan. The loan will be transferred to the beneficiary. If your wife is a housewife, how can she take a loan? If it's your kid, you just will a private property to a landed property, let's say a landed to your son. How on earth your son can afford to finance this real estate? Okay, and take note, there's this thing called TDSR. You must have the ability to absorb the loan, take up the loan. Okay, which a lot of people overlook when loan is concerned. So take note, in your planning, you must address all these loans. In your will, you must state that this property has outstanding loan, you must address it. If not, it will be transferred to the beneficiary. Now, sir, if you are the beneficiary, your father left behind property, and you got outstanding loan, you take the property or you sell? You keep or sell? Sell. Ultimately sell one. So a lot of father, mother, save a lot, don't spend whatsoever, keep the property for the child. By the time reach the child sell away. Really, this is what's happening, what I'm saying. Alright, they will not keep the property, or your children will not keep the property. It's only the parents that hold back, don't sell, don't do anything. Alright, stage it on their food or whatsoever, but the children receive it, sell. Confirm what? If I'm there, I also sell. Right now, if your father live behind a property that's 30, 40 years old, you want to keep it. If it's a private property, landed, also don't want. Why? Landed, the cost of maintenance, you know how much or not? Later I'll share. Alright? So take note, addressing liabilities.
Question. So a lot of properties, I think most people's properties, we have mortgage, right? So this actually happened to me when my father passed away. So property came down, okay, to me,
Singapore properties, huh?
Singapore property.
Okay.
But it's got a mortgage.
Yeah.
Okay, and joint owners.
Okay.
2 owners, okay, both in Singapore. I'm PR, right? So both in Singapore. We talked to the lawyer. Oh, they cannot do the full transfer until you get the title deed. The title deed is with the bank. The bank will not release the title deed unless you repay the mortgage. So you're stuck. You have to repay that mortgage. So then you talk to the bank. Can the 2 owners, the new owners, get a mortgage? Oh, you're subject to TDSR.
Yes.
Based on that,
Correct.
you cannot get a mortgage.
Correct.
So the property, I call it stuck.
Yes.
So it's stuck there, and then I asked the bank, well, how long can it stay there? The bank says, so long as you pay the
Pay the-
mortgage,
yes.
we don't foreclose.
Yes.
It can stay there forever.
Yeah. Yep.
So the
But-
property's stuck there.
Yeah.
But then
the
I'm worried when I die, though, it's stuck, it's just a mess for my
property is
kids.
still stuck there.
Yeah, it's stuck,
So
because
in
I don't
your
wanna
will-
pay the mortgage back.
So yeah, so in your will, you also need to talk about this stuck property.
What I'm saying is then it creates, then to
Yeah,
my kids,
yeah.
it's like, the
Yes.
theme was,
Yes.
is it a good thing or a bad?
Yes.
It's a burden to them, to my trustee and to my
Can-
kids, it's
can-
gonna be a major
So
headache.
can I be honest with you?
Yeah.
Property, if you never plan properly, it's always a burden. But if you plan properly, it will be a gift.
Yeah.
If you plan properly, it's a gift. If you never plan properly, it's a burden. Yeah, in this situation is a classic example. That's why I say ultimately sell.
So the
Ultimately,
mortgage is the main problem.
Yes.
That's what I say.
Always
So
the
if you
problem.
have, let's say you have a portfolio, you've got 20 properties, you think you're very rich.
Yes.
You have everything like this, but everything's got a mortgage.
Yes.
So you give it to each of them, even
Yes.
if you do the, instead of 50, 25, 25, let's say you say, property A, B, C goes to this kid, property D, E, F goes to this kid, but each property he gets has a mortgage.
Yes.
So they cannot effect the full transfer
Correct,
of
sir.
title unless he repays that mortgage.
Yes, sir.
So it's a headache for everyone.
Yes, sir.
Unless
Thank
you
you
get
so much.
some
You
solution.
solution.
I sell you the solution. Who wants the solution? So the solution is then you get insurance tied to each mortgage, each property. However, I check rates on that. The rates are much higher than just getting pure life insurance rates.
Yes, yes, correct.
Life insurance is the cheapest one.
Yes, correct.
So then you just get a huge master life insurance policy, and that you give to all the kids so they can repay off all the mortgages.
Yeah. So we get so usually we'll put in the will a policy, the policy number, and then we instruct the executor to pay off the loan so that we transfer the title to the kids without any mortgages.
Right.
So we definitely have to put in the will all this instruction. Yeah, if not, the estate have to pay for it. If not, the children have to pay for it.
Right. And they're all gonna be stuck.
Yes,
So
correct.
that's what you needed, you needed life insurance, and you didn't write down life insurance, repay all these mortgages.
Yes, you instruct the executor. You have to give instruction to the executor to distribute, settle all this, address all this first. Before paying any other thing, pay my mortgages first.
Right.
First thing is property mortgages first. Next one, the lack of planning. This one is lack of planning. Okay, so let me show one. Okay, so a lot of time when guys do their planning. Okay, so this is an investment property. Let's say this is an investment property. The father has an investment property. And when the father drafts a will, when they talk to the lawyer to draft a will, you know what they always say? Okay, I don't have a lot of money. I don't have a lot of things. Keep it simple. My will planning, keep it simple. Give 50% to my wife, 25% to my son, 25% to my daughter. Is it common, guys? Correct. Because you want to be fair, and you want to take care of your wife, right? Okay. Now I do a survey. Women, if you will do planning, will you do this? Confirm no. Women will say 0 for my husband, 50% for my son, 50% for my daughter. Why? Because if my husband remarry, all the money will be the new wife will cheat all away. To the women, only men get cheated. The women will not get cheated. You know why I know? Because my wife also mentioned. Okay, so take note of that. Alright. So what happened is that which is common. Without planning, just do that. Okay, done. He died, and the property, 3 of them inherit. Based on the share that's mentioned here, 3 of them all inherit. Okay, inherit their shares already. Everyone is happy because they have a house to stay, and now they got extra investment property. So everyone is happy. Okay, everyone is happy. Okay, now next. Let's start with the son. The son is 28. About time to get married. Correct? About the age, 28 to 32, Singapore based on statistics, 28 to 32. Okay, a guy will want to get married. Okay, let's say he would get married. He found a new girlfriend, he want to get married. Most basic thing in Singapore is when someone get married, a young couple want to get married, they go and apply for BTO. Correct? Now, can this young couple apply for BTO? Why? Because they are private property owners. Even if they own 1%, they also come by because they are private property owner. So they have to give up the opportunity to buy BTO. Now, for the son, the new wife, can the new wife accept it? The wife will jump to the ceiling. Right, the wife will jump to the roof. Why your father go and will this property to you and you go and inherit? Now we cannot apply for BTO, correct, guys? Confirm sure cannot left and right one, right? Confirm sure cannot left and right one, right? Because why? Because we do not know. Now, we do not know. Now, with proper planning, we can actually avoid that. But what happens is that a lot of people are not aware of it, just inherit. Actually, the son, if you want to inherit, can get the mother to hold. Can do it. You can renounce. Okay, get the mother to hold. Then he has no share. He didn't apply for property. But because he inherit already, cannot already. Okay, once you inherit, cannot already. Via a will, you can reject inheriting. Under ISA, cannot. Okay, under ISA, cannot. Under ISA, if your father leave behind, your father passed away without a will, ISA you inherit, confirm you have to inherit. Alright, but for will, the son can say to one. Okay, but in this case, let's say the son already. So now he cannot apply for BTO. Let's say he cannot apply for BTO. You know what will he do? If you were him, what will you do, sir? Sell the 25%. Let's say don't sell first. Let's say you opt for private property, can you say you're going to look for one property, private property with the wife? Okay, and if you say private property, you're going to look for private property because they can't qualify for BTO. Let's say you're going to look for private property. Private property, let's say a cheap one, 1 million, don't know have or not. Even have only can enter, left, right is the wall, no toilet, no kitchen. Okay, so private property. So new launch got 1 million. Don't have already. Yeah, only, okay. Very sad, very sad. So let's say he invests in a small one, 1 million, 1 million. Okay? Sir, can I ask what will be the problem you'll be facing if you purchase a private property? How many percent?
20%.
Huh?
The
Second property? 20 plus anything, all add in about 25%. 1 million, he has to pay a tax of 250k. For a young couple, got 250k. This time around, the wife will not jump to the ceiling. The wife will jump to the moon. Understand? 250 tax for a young couple won't be a big amount. So what will happen? Will they proceed with this? No. Then the next one will be what he said one. All the guys will look for who? Sell to who? Confirm look sell to mother one. Mother can help one. Mom, please help me. Correct now? Right, mom, please help me. And or if the mother will hear that, would the mother be upset? See, you inherit this house for free, and from your father for free, and now you want to sell to me. You think I can come? Right or not? You give the property, your father leave it for you for free, you inherit for free, and now you want to sell it to me, your mom? Are you sure or not? Then the mom relationship with the son and the daughter-in-law sour because of that. Because why? Father never planned properly. Right. Now, but listen.
Do you mind if I ask a question?
Sure.
All right, you're on a rhythm. I don't want to.
Sure.
Okay, so if the son says to mom, okay, mom, you buy from me. She says, okay. Does he have to pay SSD?
Yeah, later I'm going to talk about that if there is. Okay, so what happened is that. Okay,
Says later.
yeah, I need to keep you on suspense. Okay, so the son will look for the mother and buy, and you know, all of us know, all mothers. Mother should take care of the son one. Oh, we die, right? Sure, mother will still take care of the son. Son, I buy over your shares. Son, I buy over your shares. Okay? Now, question. If the mother is willing to buy over, the first question is the mother got the cash or not? Okay? If the mother don't have, the mother needs to go to the bank to borrow. At her age, can she qualify? Even she qualified, because she's so old, the loan period will be very short. The loan tenure will be very short. It will be very taxing on her. Right? Then you will say, son, cannot lah. Too much for me. Too stressful for me. Cannot lah. I think better not. I better don't buy from you. But think also, even if the mother were willing to buy over his share, because to the mother is second property, the mother also have to pay additional buyer's stamp duty on this 25%. The mother needs to pay additional buy, and all duties have to be paid by the mom. Now the mom is helping the son. So who should pay the tax? The son or the mom? If you are the son, you say mother pay or you pay. Tonight you will have nightmare. What's your question? You will have nightmare. Okay, so what happened is that you have to pay the tax. Someone has to pay the tax. Okay, so end up, don't go. Then son will go and look for sister. Why not you buy over my share? Sister will tell the brother, go and find. I understand. Where to get the money to pay? Even if sister to pay, alright, the question is, but the sister, where to find the money? Alright, end up, family relationship sour. Without proper planning. Okay, without proper planning. Alright. So today, I will advise my customer, don't dish your property to too many beneficiaries. It will create this problem. Especially for the next generation also. Because either they cannot qualify to buy HDB or they cannot qualify to buy other private properties. Kids have their own wishes, kind of property they want. But just because they inherit under the Bopian Act, they inherit from you, then after that, stop. Okay? So all these are things that a lot of MOP or whatever, all the P, all the tax, all that, all come on. Okay, so take note of all this. Alright? Now you want to know about tax, MOP, all this, ask the property expert. Okay, they will share with you. Okay? Alright, so this is like this.
So one question. So just now I mentioned, right? So the mother's buys over the 25% from the son. So can it be just in name that I buy over? So we go to do paperwork. I give you $1 just to buy over.
No $1 nonsense. No $1. If you're the mother, you will say $1. No lah, it's my retirement fund. Okay, so no $1. You have to pay full. And even the tax you have to pay full also. Okay, to the IRS. Okay, yes sir.
What if all of them agrees to just sell away the?
Yeah, all of them have to agree. But I can tell you, property got black magic one. You ask the mother say, hey, this one the father leave behind one, cannot sell. Wait, your father come back, cannot find the house how?
Stay away.
Wait, your father come back, cannot find the house how? Find other people the house, he get angry how? Right or not? There's a lot of people who believe in that the spouse still come back. Okay, because that's why I say property got black magic one. Everyone forever want to hold one. Alright? Right.
The question is, even if you want to sell, they have to inherit before they can sell. Otherwise, they don't own it.
You can sell it before you inherit also can.
Oh, you can.
Yeah,
Okay.
you can sell it before you inherit. So during the probate process, tell the lawyers to sell it straight away.
Okay.
Yes.
Okay, let's say our property is already under joint tenancy,
Mm.
but we also have a will that will in this way. So what will happen to the property?
Joint tenancy has a right place. Joint tenancy will come first. The will will not be applicable. But in the will, we still will mention. What we mention is that if I'm the sole owner of that property, yeah, because it could be a situation where one party pass on, he becomes the sole owner. So it's good to put inside the will the provision that in the event if I'm the sole owner of the property,
But
so it's good to
otherwise,
that.
Joint tenancy will override.
Yeah, joint tenancy will override whatever. Okay, okay, law of the land.